well, just so the panelists know, I'm going to start wrapping this up. Last question from Mr. Blanchard, about 4 or 5 minutes before you, just to get the transition of the other candidates up to be slaughtered. He's down. Okay. Well, I'd like to welcome Bill Gonzalez, the incumbent judge in Department F, and Denise Gentile.
I say Gentile, actually.
Gentile. Okay.
Gentile, yes.
And please feel free to throw something at me if I screw something up. They have been. I'm very easy. The way this is going to work, just some rules. Candidates are allowed 1.5 minutes to introduce yourselves. Panel members are allowed 30 seconds to pose a question. Candidates are allowed 1 minute to respond. Tough to do, but I'm sure you can do it. Panel members are allowed to ask one question. The question may be to one candidate or to both of you. The rules say that you can only answer yes or no, but I'm going to give you the liberty of 30 seconds. Maybe sometimes 45, just depending on the severity and how important I think that question is. Boy, I do have a lot of power, don't I? Okay, this is not a forum to air personal grievances, so panel members, please keep your questions generic to the best of your abilities. Candidates, do not mention other candidates in your responses. And as we do have sitting judges, it is incumbent that we all keep in mind as panelists that we're not allowed to ask about any specific cases currently going on today. So I appreciate you, Dr. Williams, for bringing that to my attention. That being said, candidates, introduce yourself. Ms. Gentile, please go first.
My name is Denise Gentile. I moved to Las Vegas in 1975 with my family when I was 10 years old. Went to grade school here, high school, graduated from Clark in 1983. So you guys are doing the calculations of how old I am. I went to UNLV, graduated with a business administration degree with a major in accounting, then went to law school in California Western, returned in 1991, and began my practice immediately in the family law arena. So from that point forward, I worked with Denise L and Associates. He put me in the family law section of his office. Went from there to Kent Dawson's office. He's now a federal judge, but worked with him in family law department. Thereafter went on my own for 6 years, practiced family law and a little bit of general practice, and thereafter went to a firm called Dickerson, Councilman, Parker, where I worked into their boutique family law department and was mentored by Bob Dickerson. And then thereafter, he and I broke off and had our own family practice, where we were fortunate enough to represent everybody from the pro bono litigants to the most wealthy of clients and everyone in between. So I really had a very vast breadth of experience in terms of the family law cases that I've been able to be a part of. And then after I left that practice, I went to Jolly Erger with Woodbury and Standish, where I was also working with Tom Standish, who's a great family lawyer, and was mentored by him for a short time.
Thank you very much, Ms. Gentile. And Mr. Gonzalez, your turn, 1.5 minutes, please.
Very good. I'm Judge Bill Gonzalez. First of all, I'd like to thank all the military men and women on the panel and here present today. It is because of your courage, it is because of your selfless sacrifices that you've made not only for you but for your families, that we have the liberties that we have today that allows me to sit on the bench and to enforce our Constitution. So I thank you for that very much. By way of history, I have a great-great-grandfather who was in the 24th United States Illinois Infantry from 1861 to 1864. He fought for the North for the rights of all citizens, all Americans. Also have a brother-in-law who served in the Navy, and I have the husband of my niece who served in the Army and is currently a peace officer in I guess it'd be South Los Angeles, a very difficult precinct that he's in. Also, I'd like to note that the very first law clerk that I hired as a sitting judge is John Pirro. John served as a combat medic for the United States Army, and he did an excellent job in my department. By way of being a judge, I've been on the bench 5 years now. I went through the judicial selection process. That process was overseen by Justice Hardesty. He was the chief judge of the Nevada State Supreme Court. There were members from the community, attorneys, members at large. I was selected as one of the top 3.
Thank you, Mr. Gonzalez.
Thank
And
you
both
very
of you
much.
as candidates, please don't take it personally that I cut you off, or panelists, but most of the people in this room carry or have carried a gun.
But he does enjoy cutting off.
If you're cutting into our time, we'd like to cut you off also.
You are more than welcome. That being said, our first question will be from Ms. Minhares over there on the end.
All right, this is for Mr. Gonzalez. What do you do to help change the bias or perception that family court judges always rule in favor of the mother?
Well, coming into my courtroom, anybody who comes in, my starting point is joint physical custody. And when people come into the courtroom, I explain that. I cannot change the perception outside in other departments, but that's my starting point. What I tell parties initially when they come in, the most important decision that you're going to make as parents are the decisions regarding your children. And you should be making that decision, not me as a judge. You know, forget employment, forget your income, the house. It's about the children. And what I do is I send the parties out to have a discussion on temporary orders. If I can have them reach some type of resolution, even on a temporary basis, then I'm able to have them to work through to get them in resolution mode and out of litigation mode. So when you come into court, that's what you hear every time. Again, that I start joint physical custody, but there are exceptions, but that's how I try to change that perception in my department.
Perfect timing. Ms. Fee, you have the next question.
Okay, I want to stick with education, because I feel like education's a big part of every child's life, and so I'm sure you're faced with differences in opinion when there's divorces and that type of thing. So my question, with the new Common Core legislation that Nevada is under, have you familiarized yourself with that? And do you feel the need to do that as you're presiding over these cases when there's a difference, the parents have a difference in how they want their child educated?
Ms. Gentile, would you like to take that first? You have
I'm
30 seconds.
unfamiliar with the Common Core legislation. I'm unfamiliar with the Common Core legislation.
Okay, well, that was my question. Are you familiar with, because I think it's something that we need to have.
Okay,
A
Ms.
judge.
Gentile is a no. Mr. Gonzalez, 30 seconds.
As to the issue regarding education, if you have joint legal custody, decisions regarding religion, education, medical, those are important decisions. If they are unable to reach an agreement regarding education, the default would be the Clark County School District. What I would say is that there have been children that have excelled in the Clark County School District and in private, but the key is in the home, getting the education support in the home.
Thank you very much. And Dr. Hawkins, would you please? Next question.
For Ms. Gentile, historically in Clark County, we've been very slow to unseat a sitting judge. Most campaigns fail unless there's been a problem. So in your case, in which case the bar usually finances a single candidate. So is there a problem here, or do you just simply see yourself as a superior candidate?
1 minute, just 1 minute. Mr.
Okay. I think overall, I've watched the different judges be elected over time, and having been practicing in front of them, I think that I would be the superior candidate in this particular case. As I've mentioned earlier, I have 23 years of family law experience. I currently work for myself. I didn't get to say that. I went out on my own, and I have 4 years now in my own practice. And I just think that it's very important, having presented cases to judges who've had very little experience holding the hands of the clients through the process. And I've been with the father, the mother, the wife, the husband, the people who have children, the people who don't, people who have alimony issues, child support issues, custody issues, business valuation issues, everything in between. I think that's very important to understand the nuances of the cases. So in terms of, I don't have an axe to grind with Judge Gonzalez particularly, but I think that between the two of us, I'm the superior candidate because I've had that experience, and I think it's very important for the community. The community needs those judges to be able to handle all those different issues.
Thank you very much for your response. Mr. Jonas, your question, please.
Okay, my question is specifically to Judge Gonzalez. So one of the other panelists talked about education. So Judge, educate us on the Soldiers and Sailors Relief Act, what it means to you, and do you support it?
It means to me that our men and women serving in the military, if there is a custody case or another civil action that's going on, that their rights are protected while they're out being deployed protecting our country. And I can't think of a more important act for our military personnel, because if they're out, you know, somebody should not be filing a motion to change custody when they're not in a position to defend themselves. So that's my understanding of, at least for the family court, that part of the act.
Okay. Steve, if you would just give me a brief follow-up.
As a veteran, I will absolutely give you the liberty.
So, Judge, on that, just a follow-up question. Do you think that at times veterans will use their military service as an excuse to try to get leniency from you on custody issues, especially with the Soldiers and Sailors Act?
You know, I've been on the bench for 5 years. I have not seen that particular issue come up. What I would tell you is most people come into court and they try to show their best side and show why I should rule in their favor. But that particular issue has not been an issue in court. And my ultimate determination, whether you're in the military or not, is I have to make a finding based on what's best for the child. And in cases of custody, I have ruled in favor of service personnel, and I have ruled in favor of non-service personnel based on the facts of each case.
Okay, thanks, Judge.
Very good. Dr. DeMarais?
Okay. In attempting to treat both parents equally, courts often fail to understand that the parents may not be of equal importance to the well-being of their children. Children who are separated from their primary attachment figure are more likely to suffer depression, low self-esteem, and to commit suicide when they're older. Courts routinely subject children as if it were more significant than primary attachment or abuse. Custody courts are required by statutes to act in the best interest of children. How will you be weighing the harms and benefits of any proposed custody visitation arrangement?
Doctor, I assume this is to both candidates?
Yes.
I give you both 30 seconds to respond. Ms. Gentile, please.
Well, I think you need to look at all the facts of each case, and each case is different. You obviously rely heavily upon those attorneys who are representing the clients so that you are educated completely on all of the facts related to each of the parents. And obviously each parent is important to the well-being of the child, and what each person's role may be different. And you want to make sure that you maximize each parent's benefit to that child as it relates to timeshare, as it relates to what involvement that parent has. And that is really important in understanding who you're seeing when they come in front of you.
Thank you. Ms. Gentile. Mr. Gonzalez, same, 30 seconds, please.
What I've seen in the courtroom, and I believe what the studies show, is not the determination of primary physical custody or joint physical custody that determines how well a child is going to flourish. If the parents are co-parenting and working together, the children will do very well in both homes. It's when the children are stuck in the middle of a nasty custody battle, whether it's primary or joint physical custody, that's when you have the negative impact on children.
Perfect timing. Judge Luke, you have the next question, sir.
Thank you. I will disclose to both of you that I will not be voting on the endorsement, or I will not be participating in the deliberations of the group that does the endorsement. We do know that the number of courts judges are limited because of budgetary and space limitations, and yet the number of cases keeps increasing, and so forth. So what programs do you propose, or what ways would you restructure the courts to increase the efficiency of case processing and case management, and using all the resources available and techniques available? What would you do to improve the efficiency of the courts?
Mr. Gonzalez, you go first, please. 1 minute.
Okay, first of all, family court is not often the best place for families because of the stress there, the cost of litigation. Anything that we can do to have alternate dispute resolution is welcome. We have a program through the UNLV Law School. It's a mediation clinic, It's a community service. Parties can come in and resolve that in a non-litigation atmosphere. Again, I have 2 ante rooms outside of my courtroom that I use on a regular basis to try to get the parties into resolution mode to focus on the issues. When we come into my courtroom, there's a lot of negativity in the pleadings, there are a lot of personal attacks, and when they come in, I just start addressing issues that need to be resolved instead of focusing on the negativity that's going on in the courtroom.
Thank you, Ms. Gentile. 1 minute.
Okay, in terms of the systemic issues of how to make sure that these cases get through the process quicker, or maybe you have to avoid court, obviously I'm not within the system now to know all the intricacies of the program, but I do believe in ADR, just as Judge Gonzalez talked about. If we could prevent them from having to come to court and then be sent out away to ADR, that would be obviously a benefit so that you don't clog the system and then have to send them away later. I know that some judges order mediation before the case actually gets in front of them so that the parties don't have to go to court to be sent to mediation. I think that's a benefit. If there are other programs, I think we talked about the voluntary mediation program that's being implemented, that would be fabulous to help parties who would prefer to do it before they get the cases filed and started within the system. But again, I don't know the intricacies of the programs now that are in this, the behind the scenes portion of it. Now, obviously, learn any information I can give from the perspective of having been a lawyer within the system for 23 years as to how to help those programs benefit the public.
Thank you very much. Almost perfect. Mr. Lamb, your next question.
This is for both candidates. Are the current spousal support laws outdated or ridiculous, and why?
Ms. Gentile, I'd like you to take that first.
Outdated.
Reset my time clock.
Obviously, there are some splits on this issue, but I think that having done many Illinois cases in the system, the statutes allow and the cases allow the judge's broad discretion. I think that's very important because every case is different, and obviously the goal of the judge is to be able to make sure that the rulings are fair and equitable, and the laws of the statutes allow the judges the discretion to do that. And every case is different. I mean, you have people coming in with no money. How do we support both these parties when they come in with very minimal income? How do we support parties who've lived a fantastic lifestyle and now they're going to have to divide what might be a significant income? What are there are factors that allow a judge to make those decisions, and every single one of them is different. And each one of them has its specific issues that arise that the judge needs to determine what makes the most sense. So to say that they're outdated, I think that they're actually done pretty well. I don't think you can do a formula to be able to say to each party that comes to you, hey, this is what
Thank you, Ms. Gentile. Mr. Gonzalez, same question. 1 minute.
I agree. I don't believe that they're outdated. There are certain areas that you have to rely on the judges to make, important decisions and to allow them to have discretion. It's not a cookie cutter type of a situation, and you have to look at the length of the marriage. You have to look at the resources that the parties have. You have to look at if one parent was a homemaker. There's a number of issues that you have to look at. If one, for example, earned a medical degree or a law degree during the time of the marriage, that person's going to have an advantage, after post-marriage. So those factors, you need somebody who's on the bench that's going to take the time to consider in each and every case what an important amount of alimony would be, and there's really no way of changing that other than looking at the case and allowing the judge to make the right decision.
Why did you pay alimony forever?
You want me to answer that one first?
Particularly.
All right, then I won't.
Ms. Melendez, your next question, please.
My question has to do with kind of just like the challenges that you find as being a judge or as being a family law attorney. What are the most difficult cases that present themselves to you, and how do you deal with those cases? And for you, Mr. Gentile, to be more of how are those cases as far as dealing as an advocate for your clients?
Mr. Gonzalez, would you take that first, please? 1 minute.
You would think that some of the more difficult cases that we would deal with would be the abuse and neglect cases, cases where parents have serious alcohol issues or methamphetamine issues. Those, in fact, happen to be the more easier cases to deal with, because if you have a methamphetamine addiction, not likely that you're going to have anything but unsupervised visitation. The cases that cause me the most restless nights is when I have two good parents, two good nurturing homes, and these children are are receiving the best, and one parent has to move from our jurisdiction because of employment or other issues, and I have to make a determination as to which parent that the child will live with on a primary basis, those are gut-wrenching cases. Those are very difficult cases, and those are the ones that, again, cost me the most, sleepless nights.
Good timing. Ms. Gentile, the same question. 1 minute.
I think every case has its difficulties, otherwise the parties wouldn't be there. So you have to be able to analyze the case, try to resolve the issues that are resolvable, and then take your clients to the court when you can no longer resolve the final issues, or all of the issues if they can't resolve them. But a lot of our biggest issues is not knowing what will happen when you get to court, because you have inconsistency in the judges. You don't know what this judge will do versus what the other judge will do. Some judges have had experience in these areas and some judges have had none. So it's very difficult for those of us as attorneys to be able to advise our clients, hey, this is your judge and this is what's going to happen if you get into this courtroom, because all the judges are different, obviously, and they have that discretion, and I understand that, but when they haven't had experience in these types of cases, it makes it even more difficult for those of us who are advising our clients as to what might be the outcome. So that, to me, is more the difficulty than anything. I can navigate the system, and I can advise the client on the law, but how will that law be applied when you get there is the difficult part.
Thank you. Perfect timing as well. Mr. Blanchard will ask you your final question. I will give you 1.5 minutes to answer and respond to this, as it is a very important question to begin with. So, Mr. Blanchard.
Thank you. First, I want to thank you both, you for running, Mr. Tilly, Judge. Thanks for trying to return onto the bench after knowing what you know and have seen. If you can you give me one quality that you possess that makes you the best candidate for that seat?
Me first?
Yep, go ahead.
Experience. And if you want me to give you more, I can give you more, but experience and having the breadth of knowledge, the breadth of the experience, having been doing this for 23 years, I think that's what I bring to this process, and I think it would benefit the community to have judges like that on the bench.
Keep going.
Keep going? Oh,
Yeah, 1.5 minutes.
I got 1.5 minutes. Oh my goodness, okay. And I have I have the temperament, I have the understanding. Like I said, I've had the fortune to be able to represent so many clients in the community, to understand all of their issues, and again, I haven't represented everybody in the community, but I've had enough experience to know that every single case has its own nuances, it has its own issues, and when you've been there with the litigants every step of the way for 23 years, I think that just gives the community a better judge than those of them that have not had that experience.
Awesome. Great response. Mr. Gonzalez, 1.5 minutes.
I think the most important quality that you should have as a judge is to care about people. The decisions that I make impact lives every day, and it could impact them for a very, very long time. And if you just don't have that care and that love for your fellow man, I don't think you should be on the bench. That's one of the most important qualities that you should have. I think the second quality is you shouldn't think that highly of yourself. If you think that you know everything, you have all the right answers, and you're going to be judging people, you probably should not be on the bench. And you need to allow the litigants, the parties, to be involved in this process. I think what people want, they want a judge who's going to listen. They want to have their day in court. They want a judge who's fair. They want a judge who's going to take care of things in a timely fashion. I've been involved in this community for many, many years. I've served on the Housing Authority. I was appointed by Mayor Goodman. Part of our role was to, seek after affordable housing for our veterans. I'm on the advisory board for the law school clinic. I've been, for the last 10 years, very closely involved with the law school. My 5 law clerks have all been from the UNLV Law School. I've had 4 women, and as I mentioned, John Pirro, who was a medic, a combat medic. I've had an African American, I've had an Asian American, I've had a Persian American. I try to provide opportunities to minorities in our community. I've been a Boy Scout leader for the last 15 years. Both of my sons have their Eagle Scout rank.
Thank you, Mr. Gonzalez. Panelists and audience members, please give these candidates for department.
One moment, wait. I have a question. Before we release them, it's my turn.
Yes.
Thank you for joining us here today and allowing us to scrutinize you in public this way. I think everybody here probably knows a family who has split up, and there are children that are caught in the middle of sometimes very bitter disputes. And I'm sure that nobody is ever happy in a case, regardless of what the outcome is. But I hear judges a lot, not just in family court, but in other courts too, talk about the best interest and things like that. And I would like each of you, if you could, to speak to me about what you think qualifies you to know what the best interest is of a child. And oftentimes also I see judges who treat children as if they are the possession of the state or of the court and not children who belong to parents. It's almost as if the court thinks they have more rights than the parents do. And I'm sure that there are cases that warrant that, but I'd like each of you to address or speak on, if you can, on the issue of what makes you think that you are the authority over what's the best interest of a child.
Yes, best interest of time,
Yes, Council,
I'll give you a minute to respond.
do you mind if I respond first?
Well, I was gonna look at you to respond
All right,
first.
thank you, Councilman. I do not believe in any case that I should be the deciding person who what's best for children. I believe that should be to the parents. And most parents that come into court, the vast majority, if you talk to them, reasonably with common sense, and you explain the process and you explain how important it is for them to work together, that their ideal situation, that they're not going to be able to see their children every single day, the vast majority of those parents respond and you're able to resolve those issues. There's a handful of them out there, they're just miserable, they're bitter, they're angry. There's nothing that I can do as a judge to help them. And the only thing that I can do is to try to put in orders to protect and isolate the children from those types of parents, because those are the children, watch out, they're going to have difficulties. But the vast majority of the parents, they're able to come in and make that decision, and I always push back, because I want them to make that decision on what's best for their children and not me.
Thank you, Mr. Gonzalez. Ms. Gentile, 1 minute, please.
I think your job as a judge is to make that determination when the parties can't. The law says that you're to evaluate the situation and look at what is in the best interest of the children. If the parents could make that decision before they got to court, they would have done it already. Clearly, the lawyers are now supposed to present to you the facts of the case, tell you why they believe their client should have X visitation schedule or why someone should have a joint custody schedule. If the parents can't agree under the statute to joint custody, then it's your job as a judge to evaluate all the facts and determine what you believe as the judge, and that's what you're elected to do, is to make that decision as to what you believe is in the best interest of the children. They're not supposed to then be sent away to say, you figure it out. If they could, they wouldn't be there. And that's why they need you to make that final decision for them and look that you've done the best you can with the facts that have been presented to you by both attorneys or the litigants themselves, if they're in pro per, to finalize the decision and send them on their way so that they can now implement that schedule.
Thank you very much. Both of you had very good responses to these wonderful questions. Panelists and audience, again, thank you for